Now calling the matter of the people versus Cinnamon Woodford. This is ticket number P1217275. Count one, no plate on a trailer. Count two, no insurance misdemeanor. Count three, drive while license suspended. Appearance for the record, starting with, I don't think counsel is represented in this matter. So Ms. Woodford, state your name for the record, please.
I'm here about special appearance, Vicoactus.
Still unpredictable as ever, today's focus shifts to a courtroom encounter unlike most. When her name is called, a woman steps forward with an unusual approach. Introducing herself with a string of puzzling legal jargon, she claims to be making a special appearance, a phrase often linked to unconventional legal theories. She carefully avoids stating her full name, instead wrapping her identity in cryptic terms. The judge, composed and unfazed, waits in silence. The tension lingers, until finally, she drops the theatrics and states her name plainly, Cinnamon.
Cinnamon.
Last name too?
Woodford.
All right, ma'am. Now, you know you have the right to have an attorney in this particular matter. This is a misdemeanor matter, and by right, under law, you have the right to have a representative in the form of an attorney for this particular matter. Would you like to have an attorney in this matter?
I do not consent to these proceedings. The offer is not accepted. I do not consent to being surety of this case and proceedings. I demand the bond be brought forth immediately so I can see who will indemnify me if I'm damaged.
Okay, so the question that I asked is that, did you want to have an attorney provided for you in this particular matter, Ms. Woodford?
I do not consent to these proceedings. The offer is not accepted. I do not consent to being surety of this case and proceedings. I demand the bond be immediately brought forth so I can see who will indemnify me if I'm damaged.
The judge straightforwardly offers her legal guidance, but Cinnamon returns to her rehearsed routine. She sidesteps the court's authority, brings up the idea of consent, and demands to see a bond, all familiar tactics from the Sovereign Citizen Strategy book. Still, her words do nothing to change the facts. The judge, composed and patient, lays out the actual charges: no license plate, no insurance, and driving with a suspended license. Rather than engaging with the reality of the case, she loops back into the same scripted lines, drifting further from any real resolution.
Right now, you're quoting from the UCC. This is a criminal/traffic matter. So those proceedings govern these type of cases and these type of matters.
What crime did I commit?
Ms. Woodford, if you do not wish to participate, then what ends up happening is that this matter will go into a show cause. After the show cause, then it will enter into what's called a bench warrant for your arrest until you handle this matter, at least the misdemeanors. And these are all misdemeanor offenses. So that's how this is handled on this particular end and this particular point. The offenses that have been alleged at this point in time is that there were no plates on your trailer, that there was no insurance on a Chevy vehicle, that's a 2007 Chevy vehicle, and that the driver's license was suspended that you had.
The judge patiently notes that Cinnamon is citing the UCC, a civil statute that has no bearing on her criminal charges. She insists that declining to act as the surety somehow halts the proceedings. But in truth, criminal courts don't require permission to continue. The judge attempts to clarify, but it's clear she's firmly anchored in her own interpretation of the law. As the judge delivers a final warning, appear in court or face a warrant, Cinnamon offers no plea, no cooperation, just more tangled rhetoric.
And so those are the offenses that have been alleged at this point in time. Right now, they are just allegations. So you have the right to have an attorney, which I don't know if you would like to have that right or not. You have the right to have a jury trial. You have the right to have a bench trial. A jury trial is a trial before 6 people of the community in the city of Detroit who come and they will hear the facts, and based on the evidence and based on the law will make a decision. A bench trial is the same thing, only a judge, being myself, would sit there and I would hear those same facts and evidence and apply the same law in the same way. You also have the right to plead to these matters. There can be an officer.
I'm not here to plead, ma'am.
Ms. Woodford, these are your choices. So it's up to you. It's a decision that you have to make. It's not going to go away, okay? Just because you want it to go away, it's not going to go away. There is jurisdiction for it. So it's your decision on today. If you don't want to participate, then it's going to go into show cause because you can keep coming and it's just going to hang out there. But eventually we're going to have to adjudicate this matter at some point in time because it cannot remain on this docket indefinitely. So you have to make some decisions as to what you would like to do with these matters.
Well, I still do not consent to these proceedings.
At this moment highlights just how quickly a case can fall apart. Cinnamon claims she's never held a driver's license even though she's charged with driving on a suspended one. That contradiction alone undercuts her credibility. The judge points out that legal counsel might have helped her navigate the situation more effectively. Still, she stays locked into her script, missing every cue. Each response pushes her further off track, doing more harm than good. It's a textbook case of speaking without understanding the legal consequence.
So if you do not want to participate, I'm going to be forced to put it into what's called a warrant. You have to participate. So you have to come in and ready to go with something. I know you may not like it, but as a person who is a citizen of the United States of America, who is a person who lives in Michigan and is utilizing the services of our world and our community, these are the things that have been alleged. Now, if you're saying that the officer wasn't, correct in those or something, your license was valid or you had car insurance and you can present all of that, then we can try and figure out if we can get a new offer or something different. But other than that, you do have to stand for these particular allegations that have been made at this point in time.
Something unexpected shifts the room. The judge begins asking Cinnamon questions, ones that could be used against her later. Just as things begin to unravel, public defender Matthew Dupree steps in. Though not assigned to her case, he respectfully objects, reminding the court that she's unrepresented and could unknowingly jeopardize her defense. In a surprising turn, the very attorney she declined becomes the one protecting her from a serious legal mistake. It's a moment where the system quietly safeguards her rights even when she won single quotes.
So, I mean, I still don't consent to these proceedings. The offer is not accepted. So,
ma'am, you can stop reading that. I know they've given you a line cue that you are able to read off of, but this is as long as you utilize the services of everything in the city of Detroit and you fail to do those things, this is the ticket that proceeds. But I don't know that you failed. You said you don't have a license. But did you have car insurance at that time that you can present?
no.
Since Dupree intervenes, the atmosphere shifts. The judge stops the informal questioning and sticks strictly to procedure. Cinnamon still won't enter a plea, so the court sets the case for a jury trial. The irony is striking. After rejecting the court's authority at every turn, it's that very system that protects her rights. The same structure she resisted now works to ensure a fair process. It's a familiar scene, turning away support, until it becomes the only thing standing between order and chaos.
I'm sorry. I know I'm not on this case, but if I could file an amicus brief of sort. Judge, I'm a little uneasy with, this is Matthew Dupree, P80132. I'm a little uneasy with the questioning here just because technically if this matter were set for trial, what she says here could be used against her. And so I'm not sure she should necessarily be answering those questions.
You want your representation, Mr. Dupree?
She did not, Judge.
Did you ask her if she wanted your representation?
I did, Your Honor.
Did the court ask her if she wanted her representation?
You did, Your Honor.
You can continue to talk, Mr. Dupree. I appreciate you stepping in on her behalf.
I appreciate that, Judge. Your Honor, I'm just I just thought I would make that representation. I don't think the city attorney would actually pull the transcripts, but it is worth noting that anything she said here, could come back. So it might, I'm not sure that necessarily that questioning would be appropriate. Sorry, Judge. Thank you.
You're welcome. Thank you, Mr. Dupree. I appreciate you coming in to step to the rescue of Miss Woodard so that she understands.
It's Woodford.
Woodford. Sorry, ma'am. Miss Woodford. Miss Woodford? We have to make a decision. So how do you want to move forward with this?
Well, I'm not here to plead because I'm not here to
Would you
plead.
like a bench or a jury trial?
Are you making that determination for me, ma'am?
You have to have a bench or a jury trial. You told me you don't want to plead, that's fine. You probably should have a jury trial then. And I don't have any jury trials for this year.
Are you making that determination for me, ma'am?
If you don't make the determination, yes, the court is making the determination for you. Yes, because I have to move it. I have to move it. So it's either, well, Attorney Dupree, can I have a bench trial now? I don't want to violate anything.
No, Judge, she has to explicitly waive her right to a jury trial, and strictly speaking, she has to do it in writing. So I would say if she's saying she will not plead, that would be standing mute, and I think the court would have to set it for a jury trial.
As tensions peak, Cinnamon's screen freezes, whether by accident or uncanny timing. No one can tell. When she returns, her demeanor has shifted, calmer, less combative. It's as if the weight of the situation has finally set in. The judge remains composed, sets a pretrial date, and once more offers legal assistance. This time, she accepts. It's a quiet turning point, one that suggests she's starting to understand what's really at stake. That single choice could change the course of her case.
Sorry about that. I had a very bad power surge.
I figured as much. So no, back on the record, I figured that it happened because you kind of froze up, and my clerk informed me that you froze completely. So
Okay, thank you.
You're welcome. Okay, so I'm setting this for a jury trial because the alternate is that I can put this in warrant status. And I don't want to do that unless I necessarily have to. So at that point in time, you could be able to have your day in court to say whatever you want to say at that point in time.
Okay.
Okay? All right, so I'm going to, but I have to do a pre-trial because I don't have any dates right now. But I have your name down, but that will give you the opportunity. You'll be able to talk to the jurors. You will have the opportunity to have testimony taken. I know you don't want counsel, but you can have the right to have counsel at that point in time. Would you like to have me assign counsel to you?
I need effective counsel.
Fast forward to trial day this time. Cinnamon returns with a lawyer by her side. But the city attorney is a no-show. With no officer present and no case ready, her attorney moves to dismiss the charges. The judge agrees, and the case is dropped without prejudice. It's an unexpected outcome, from resisting the system to having it work in her favor, all because she chose real legal representation. Once again, it proves a simple truth. A qualified attorney outmatches internet theories every time.
Now calling the matter of the people versus Cinnamon Cheyenne Warford. This is ticket number P1217275. Count 1, no plates or trailer. Count 2, no insurance misdemeanor. Count 3, drove while license suspended. Also calling ticket number SP110222272. This is no proof of insurance. Count 1 of that same ticket is no receipt of registration. This is the date and time set for a bench trial in this matter. Appearances for the record, starting with Attorney Baughman, please.
Good morning, Harry Baughman for the defendant. Your name, please, ma'am.
Senator Woodford.
Thank you, Ms. Woodford. These matters are set for trial. I do not believe there's been an officer who has checked in. With the people being unprepared now at 11 a.m. approximately, at the case is set for 9, we'd ask you to consider a motion to dismiss here without prejudice. Thank you.
No officer having checked in on any of these matters, the court is going to grant your request. I'm going to dismiss these matters without prejudice. You're all set, Ms. Roper.
Thank you.
You're welcome. Have a good rest of your day, okay?
You too.
Fast forward to trial day this time. Cinnamon returns with a lawyer by her side. But the city attorney is a no-show. With no officer present and no case ready, her attorney moves to dismiss the charges. The judge agrees, and the case is dropped without prejudice. It's an unexpected outcome, from resisting the system to having it work in her favor, all because she chose real legal representation. Once again, it proves a simple truth. A qualified attorney outmatches internet theories every time.